think Stephanie is on her way in. How we doing? Prevent child abuse. Yeah. Come on up, Stephanie. All right. You all tell us when you're ready. Good? Good. Good afternoon. Today's ruling is about 200,000 active and hundreds of thousands of retired public servants, including teachers, police officers, firefighters, social workers, bus drivers, and every other state, county, city, and school system employee. These public servants have been disrespected. These public servants have been called names. They've been accused of causing harm to our children. And they were betrayed by their government that acted behind closed doors and in the dark of night. But we fought back, and Kentucky's public servants have won. Today's ruling holds the General Assembly violated Kentucky's Constitution when it turned an 11-page sewer bill into a 291-page pension bill and passed it in just 6 hours with no public comment or participation. The public simply cannot be shut out of the legislative process. It's my hope that today's ruling sends 2 clear messages to the Commonwealth's governor and its legislative leaders. First, in the Commonwealth, when you make a promise, you keep it. We promised our teachers, firefighters, social workers, police officers that if they dedicate their lives to public service, teaching our children, protecting our families, serving the neglected, that we would guarantee them a good retirement. The Commonwealth must keep that promise. Second, the Kentucky Constitution creates a government that serves the people and never shuts them out. Today's ruling is a step towards giving Kentuckians that government that they're entitled to under the Constitution and that they deserve. I want to quickly thank my team that worked on this, Latasha Buckner, Travis Mayo, Sam Flynn, Mark Ferris, and of course, the Deputy Attorney General, Michael Brown. I now want to turn it over to KEA with Stephanie Winkler.
Thank you. I just can't be more happy and excited for our public employees, especially our employees in our public schools that are vital to every single community in the state and Commonwealth of Kentucky. We, along with Attorney General and with the Fraternal Order of Police, joined together, as Attorney General Beshear said, to make sure that our government works for the people. They have not been working for the people by the rules. We need to quit with corrupt government, and we need to start governing the way the citizens expect us to govern. And that's with integrity and with honesty and for the people and for our values. And when we start doing that again, there's no stopping the progress that can be made in Kentucky. And we want to be a part of that. The public schools of Kentucky serve every single family in the Commonwealth. And it doesn't matter what zip code you live in, our public schools provide vital services for all students. And we can't do that without vital dollars from our tax base, which in Kentucky has been fraught with problems. And I won't get into that, but I just want to state clearly how excited we are for this positive decision. And hopefully we will see positive results in our professions and for our students in the many years to come.
And we would have a member of the Fraternal Order of Police with us. I believe one is on his way, but they are out there protecting our families as we speak. So any questions? Dan? We'll see. Procedurally, the governor or the legislature, well, no, only the governor, because the leaders of the legislature were dismissed, could file a motion to alter, vacate, or amend. I don't think that would be successful. And so they have a choice. They can either take a step back and take a breath and say what we did was wrong. It was wrong to shut out teachers and other public servants. It was wrong to try to pass something in just 6 hours, turning a sewer bill into a pension bill. And that if we want to enact any reform, then we need to bring everybody to the table. And if they want to go that route, then they would not appeal this. But if to them winning is more important than serving the people of the Commonwealth, then they will likely appeal. And my guess is they will try to immediately move it to the Supreme Court, which we'll be in favor of, because I believe that our teachers and firefighters and social workers deserve as quick of a final ruling as possible. Come on in. You're welcome to join us up here. All right, good.
The judge didn't rule that the changes violated the inviolable contract.
He didn't have to. So like we discussed in the oral argument, if he was going to rule that the bill was unconstitutionally passed, it voids it in its entirety. And one of the statutory canons of construction, how as a judge you go about deciding something, is you don't decide a question you don't have to decide. Now that's something you see in decisions all the way up.
If the legislature were to come back, whether in a special session or next
Right.
year, and pass the same bill, but follow the 3 readings and,
Right.
and getting a majority, constitutional majority, is this something you would challenge again on those?
Absolutely. This bill violated the inviolable contract in over 15 ways. The General Assembly decades ago made a promise to our teachers, police officers, firefighters, and other public servants that if they dedicated their life to protecting our families, teaching our children, serving the neglected, we would guarantee them a good retirement. You can't take that away midstream. You can't ask someone who agreed to come to work in part because of that promised retirement and has worked 10 years, 15 years, that you're going to pull that out from under them. That's not only wrong, it's unconstitutional.
There have been a lot of bills that have passed without having readings on separate days in the past. Do you think that this opens up a challenge to those laws?
Well, first, any bill could have been challenged on any grounds for any reason that's out there. This doesn't make anything more or less likely. But what the judge says in this order is exactly what I've been saying to you, is that there was only one bill that was challenged here, Senate Bill 151. Nothing else is being challenged. Nothing else is being impacted. The governor's claims that Western civilization would end or that this would void every single bill ever passed by the General Assembly are simply not true. Those are a scare tactic. Judges in the past have ruled the process by which certain bills went through rendered them unconstitutional and void, and they haven't impacted any other bill.
But do you think at least gets a message to legislators that bills passed this order will be subject to?
Yes. It says when you do this, you are breaking the Constitution. But the Constitution said that too, Debbie. I mean, they should have known this by now. But the opinion specifically says that this argument of don't declare this unconstitutional because we do it all the time is the reason that you have to declare it unconstitutional, is that the judiciary and the Attorney General have a duty to enforce the Constitution. And that's what we're doing here. And it's my hope, I think it's our hope, that this will create better government. An 11-page sewer bill should never turn into a 291-page pension bill and be passed in 6 hours. That shouldn't happen. So legislation should always pass in a way that's transparent and that the public can participate with. And I believe that this ruling will ensure that happens in the future.
I haven't read the full thing yet, but it seems that this ruling really hinges on the 3 reading
And the appropriation.
and the appropriation. Okay.
Yes.
So one of the things that I know the governor argued was there's this difference between at length versus in its entirety. Can you kind of go into?
I can.
Are you expecting every bill to be
First, let me say that the only decision here is on what he decided. Anything he didn't address, there isn't and there doesn't have to be a decision on, because if you rule it's unconstitutional in the process for one reason, you don't have to reach any of the other reasons. So here, the judge declared this bill unconstitutional because it did not receive 3 readings, and he didn't have to get to the at length because there weren't 3 readings. There was only 1 in one chamber and there were 0 in the other. He also ruled that this is an appropriation bill and therefore required 51 votes in the House, and it did not receive 51 votes. Interestingly, he looked at the 2 statutes, the requirement of a local government impact fiscal statement and the actuarial analysis. And while he said, because of this decision that's out there, I can't void the bill under these grounds, I suggest that the Supreme Court look at this, because the arguments that have been raised are constitutional arguments, and I think they ought to take a second look. He didn't reach, at least I don't believe he reached, the at-length part, which wouldn't require that a legislature read every single word of every single bill at every time, but what it does mean is you can't simply read the title, especially when you've changed every single word in it. The only reading that this bill got in the House after being changed was by title, and they called it a bill on wastewater. And so these are all provisions of the Constitution that are intended to slow legislation down so the public can participate, ensure that every legislator knows every part of a bill that they are going to be voting on, make sure that we understand whether the bills will work or not and what harms they might have to local government. They're a part of an open, honest process that the Constitution requires.
What would your message be to local governments that are deeply concerned now about the status of House Bill 362 as it was passed in the same manner?
Well, House Bill 362 hasn't been challenged. It will be the law. The funding and the phase-in are both still law. Now, the only thing that has been voided here are the unconstitutional cuts to the benefits for teachers, firefighters, police officers, and other public servants. Any last questions? All right. Thank you all very much.